Hi everyone, I'm immigration lawyer John Khosravi. Thank you for joining us on the live version of the show, and thank you for those watching later on in the video portion. It's June 2nd, Wednesday, 5 p.m. Pacific time, and we do every week for almost a year and a half now. We're doing a live video Q&A where you call in to ask general educational questions, not case-specific stuff, about your U.S. immigration case. So we're going to get into all that as your questions come. My assistant will post them and we'll get to that. But before getting into it, I want to remind you that we do have free raffles for free 15-minute video consultations for you at no charge. All you need to do is like, subscribe, and just post, consultation or something wherever you're watching. And my associate, every 10 minutes or so, will pick somebody to get the free raffle. So it's been really helpful. I've met a lot of you, a lot of listeners. It's been a pleasure. Thank you so much for joining us. Other than that, if you're interested in looking into a marriage green card case, you're going to get married, you have a fiance, and you're trying to understand the process, just go to this website and download the Ultimate Marriage Green Card Guide. It's the best green card guide out there for marriage cases, fiance cases, and it's free. Just go to marriageimmigrationlaw.com. Again, that's marriageimmigrationlaw.com and download the Ultimate Marriage Green Card Guide. With that, let's get it started. Conservative immigrant says, can we vote locally or not if you have a green card? Generally, you always go by the rule of do not vote in any way possible if you're a green card holder. You have to be a U.S. citizen to be able to vote. So unless you're a U.S. citizen, don't vote. There's some nuanced stuff where if you vote in a local election that's like this or like that, maybe you can get away with it. Very rare cases. I'll need to study on the jurisdiction you're in and what kind of vote it is. But why bother? Just don't touch it. Wait to get the citizenship. File for that as soon as possible. But don't vote, don't vote, don't vote. Don't register to vote. Don't do jury duty. Don't claim to be a U.S. citizen when you're applying for a job. In no way possible should you ever claim to be a U.S. citizen unless you are a U.S. citizen, because it could quickly lead to you be deported with no defenses. So be very careful on things like that. The situation could be terrible for you. I have another question from Oluwartomi. Can my mother file for my sisters in Nigeria? She is a U.S. citizen. Definitely. When you're a U.S. citizen, you can file for your children, even if the children are single or married. So either way is possible. If they're single, it's a little faster than if they're married. It's a lot faster, because when they're married, they can bring the spouse and children, and because there's more people part of that file, there's a longer line for that. But a U.S. citizen can file for those children. The key is that you should have a birth certificate showing who the mother is, so that they could connect them. And there's a lot more involved. We need to know the background of your sisters, how things are working there, all this kind of stuff. But generally speaking, to start the process, a petition for alien relative form I-131 is possible from a U.S. citizen to their child. And once we get to that, there's a lot more details we need to know, whether it's going to be able to finish it. For example, if there's prison history, arrest history, criminal history, all this kind of stuff could be problematic. Eventually down the line, there's a sponsorship requirement, and it depends on where your mother lives. If she's in the United States domicile or not, it gets really complicated after that. But if you're interested in doing it, you should definitely do it, because there is a long delay. It's years and years of wait. So you want to get started sooner so it gets done sooner. Now, one mistake people make is when they have a green card holder can file for their adult child who's single. Not married, but single. But some people wait to become citizens before they file for their adult child. And the bad thing about that is, first of all, they're waiting 5, 6, 7+ years to become citizens. So there's a baked-in delay you've added there. But then these people make the mistake of filing as citizens because there's a longer line for adult single children of U.S. citizen than there is for adult single children of green card holders. So definitely, if you have a green card and your child is single or 21, you want to file for it then and not wait to get U.S. citizenship. But thank you for the question, Oluwartomi. So a question we have, Jay Khalib asks, I-140 is already approved. This is a green card based on work, and combo card was issued. That means you file for adjustment of status as well. Can an interview be waived for employment-based I-485? Definitely. Most of the time, Trump kind of messed things up, but it looks like it's going back to most of these cases having the interview waived, unless there's a particular issue with your case that requires an interview. But there's a good chance your interview would be waived. Hopefully you submitted the medical as well, and they have that. If not, they'll send a request for evidence, an RFE, asking for you to either mail in the medical checkup, or you might have to bring it into an in-person interview. Both those are possible. Sarah asks, I recently submitted an I-129F, that's a fiance visa request. Will I get a notice indicating when and where to file the I-134 after support? is this one fiance takes his interview, does it need to be filed beforehand? No. So for a fiance visa case, you first file Form I-129F, and this is all in the Ultimate Marriage Green Card Guide. All the answers that your specific question you're asking is detailed in there. Check it out at marriageimmigrationlaw.com. But you need to file the I-129F to prove you're a real couple, and then an embassy portion starts, and that's when you submit Form I-134. It's a financial affidavit of support that you submit for your fiance. Your fiance would take that with them to the interview along with the rest of their documents to get the K-1 visa. And once they get the K-1 visa, they come to the United States, apply for adjustment of status after you get married, if you get married within 90 days especially. And then what's important there is you have to submit another affidavit of support, this time Form I-864, not I-134, but hopefully that helped. Cream Pie asks, if I'm to ask serious question, do you subscribe to the idea that American justice system is plagued with systematic racism? Well, that's a loaded kind of thing. Yeah, of course, but every country's loaded with systematic racism. Be real, we have a lot of Afghan people here. My family's from Iran, I was born and raised here, but the justice system in Iran is hella against Afghani people. They're discriminated against. I have a client right now from China. She has a mixed child, and people treat her mixed child that's white and looks fully white with a lot of racism. In Russia they do that. In Africa they do that. That's everywhere. So this idea of systematic racism is systemic to humanity, not just America. And I've traveled around the world, I have clients around the world, I talk about this issue with them. Systematic racism is systematic to humanity. It's not racism, it's prejudice and the way we deal with each other. We look at each other as groups, and when you take away the individual humanity of someone and just look at them as a group, this happens. And that's why a lot of these things we talk about nowadays is popular with progressivism, is constantly putting people in boxes and groups and forgetting their individualism. That's one of the reasons I love immigration law and practice the way I do, is I always deal with individuals. So when someone comes to me, it's not they're an Iranian, they're Chinese, it's that it's Bob, I, or Jamshid, or Luke, or something like that. It's always dealing with the person, because that's what matters. We're individuals. And so we just got to deal with things in that way. But generally, is a justice system fully just? No, that's not. So that's just what it is. We have a question for Fatima. Hello, I'm married to a U.S. citizen on a B2 visa, and case is already filed. Would like to pursue higher education in the United States. Would affect the process, or should I wait for adjustment of status? So if you're married to a U.S. citizen, you're not really supposed to, on a B2 or expired, go to school. It is a violation, but these violations are forgiven when you're married to a U.S. citizen and applying for citizenship. So I wouldn't hold you back from going to school. The school might not understand it. Usually they will and just sign you up. But going to school, if you have a marriage case pending, is not something I would prevent you from doing if you're married to a U.S. citizen, which comes under one of these forgivenesses. So yeah, the student visa issue is a really important one. I'm getting a lot of questions right now. They're opening things up again and giving priority for student visa holders to come to the United States and not be subject to many of these bans for COVID-19, even if you're from one of the countries that has a COVID-19 ban. But be careful, there's a lot of issues. One is, every consular officer doesn't know what's going on. Every airline that's going to board you doesn't know what's going on. But one major issue I have with people filing for their own student visas or even tourist visas is when they fill out the form DS-160, this is the online application for any person coming on a non-immigrant visa, they don't fill it out with attention to detail, and they leave out stuff by accident that might be honest accident, but it becomes very problematic later down the line. For example, I have several cases right now where I've consulted where people are coming from countries that have mandatory military conscription. This is when you have to join the military in your country for 2 years, and everyone has to do it. And then countries like, Taiwan, South Korea, Iran, all these kind of countries force it. But when you apply for your tourist visa, it asks, have you ever been a part of the military? Have you ever had any weapons training? You have to say yes to this. U.S. government wants to know. It doesn't mean they're going to deny the visa, but they just want to know. But what happens is people don't fill it out, they get the visa, come to the United States, marry a U.S. citizen, and they're like, oh, I won, I'm going to get a green card now. Well, you have a thing called fraud and misrepresentation potentially in your past because you weren't open and honest about saying something and admitting something that you were supposed to tell the consular officer. Now, do they always enforce it harshly, accuse you of fraud or misrepresentation? No, but it can happen. So make sure you read all the questions, you fill it out thoroughly. And a lot of people, most people do not hire lawyers for the B2 application or student visa application. I understand why, it seems simple enough, and it is. But one small error can follow you the rest of your life. So be very careful when you're filling out these applications. it could be very problematic for you in the future if you don't completely fill out the application forms correctly. But that's the main thing I want to get, one important thing I wanted to mention, because I see this issue happen so many times, consistently, more and more nowadays, so be very watchful of it. Alright, so we have a regular pair note. Android asks, when I call the USCIS customer service number, there's no way to reach a human. Any way to check the status of my re-entry permit application since I haven't received the G1145 notification? Well, if you haven't got the G1145 notification is when you submit with your application to USCIS a request that they text message or email you your case number. This gentleman, this person hasn't done it, but they haven't received that yet, and they're worried or thinking about it. They want to call USCIS, but probably if you call them, they won't be able to tell you anything either because they haven't begun processing it yet. So just be patient. How long ago did you file the case? Wait 1 or 2 months. And then see what happens. It's just re-entry permits are not a priority. I have a case right now. We filed last July for a re-entry permit from I-131, and we still have not received the biometrics appointment. That's how backed up things are. You filed 5 weeks ago. I say your follow-up. So wait another week or two, and check your credit card account or check your checkbook, however you wrote the payment. That'll give you indication that they have the case. But 5 weeks right now with the delays that are happening is not abnormal. I don't think calling them will make a difference, and if you didn't submit the application correctly, you're just going to get it back in the mail in a couple weeks, so they'll know that way. So, we talked about the re-entry permit. This is the education I want to give. People get confused on what these documents are. So, the Form I-131 is an application you submit to USCIS for a travel document. But a travel document is a wide-ranging kind of thing. It can mean many different things. So, a travel document could be your passport. It could be a re-entry permit. This is special permission for you to be outside the United States for an extended period of time. As a green card holder are supposed to continuously reside in the United States. So if they leave, it looks bad, but you're telling the government beforehand, I'm going to be absent, please forgive it. I-131 travel document could be advanced parole. This is permission to leave the United States and come back in when you're not allowed to usually leave. Or it could be even a refugee travel document. This is a document where people who are asylees or refugees in the United States who are not allowed to use the passport of the country they escaped from, they get that as an alternative to a passport. Capital 80 asks, how long does it take to get a sibling here if you're a U.S. citizen? Well, you need to go to a chart called the Visa Bulletin Chart, part of the Department of State, and they have different timelines, and the sibling case timeline varies depending on what country your sibling was born in. Philippines, I think, is the worst. Mexico is really bad. But generally, you can expect 15 to 20 year wait from the time of filing for things to move forward for a sibling of a U.S. citizen case. Sarah follows up, how long after getting married, fiance visa, could we expect it to take for the partner to get a work permit, provided we file I-765 as part of the adjustment package? Right now, I'm easily seeing the I-765 EAD, the work permit, taking 7 months from the time of filing, unfortunately. I was on a call with some lawyers and they were giving estimates of 3 to 5 months, but realistically I'm seeing 7 to 8 months. It's getting worse and worse to get the work permission and advanced parole. It's a nightmare, to put it lightly. And that's why I don't like doing fiance visas. Only 1 out of 10 cases would I recommend a fiance visa if they're not married as opposed to marriage. Because one of the big problems is the fiance comes here, you get married, and it takes 2 or 3 months just to get married and file the case. Then you add 7 months for work permit. It's almost an entire year where the foreign spouse doesn't have a work permit and maybe does not have a social security number too. And that's very frustrating, especially if you're young and you're active and you want to work, you got to make money, there's financial needs, all this kind of stuff. That's why I try to avoid the fiance visa unless the case really calls for it, the clients really want it. But thanks, Sarah. Primrose asks, should I send my N400 while waiting for the I-751? So we get this question regularly, so I can't say what you should do. I can't say because I don't know the details of your case, whether it's appropriate, but I had a consultation with the gentleman today who I've been helping since they got married, and now I-751 is still pending. That's if I-751 is if you got married, your marriage is new, they want you to resubmit some applications after 2 years to prove your relationship is real, but they're pending a long time. They're taking 1 to 2 years, and while it's pending, a time comes where a spouse of a U.S. citizen can file for citizenship. I generally recommend people do it unless there's some issues with their case. So that's why I can't tell you what you can do in your case, but you should look into filing for citizenship. Now there's other videos I've seen online on YouTube from other lawyers saying it's not possible. That's incorrect. You can file for an N400 application for naturalization if you pass the other requirements for citizenship, residency, clean background, all that other kind of stuff. I generally recommend people doing it to get the ball rolling, but again, I can't advise you individually without knowing the specifics of your case. Lance asks, is owing taxes a bar to be denied for citizenship? Yes, 100%. On the N-400 application for naturalization for U.S. citizenship, there's a question that asks, have you ever not filed U.S. taxes? You ever owe U.S. taxes, all this kind of stuff. And if you haven't filed or have not paid taxes, especially in the last 5 years, that's a moral character bar that could lead to a denial. If it's outside the 5 years, it may be okay. You should probably go back and file them anyways. Or if you have back taxes owed, you should have a payment plan with the IRS and bring that payment plan, but they'll be discretionary whether the officer approves or not if you haven't paid back taxes. If you have a plan, they may work with you and stuff, but that's something you should definitely consult with an attorney in private about to do it the cleanest way possible. Alright, Lance Morris says, if you owe taxes when you file for N-400 but paid before the interview, you just got to keep records. So you have to have a payment plan or paid, so when you go to the interview, the officer knows what's going on. I have to see the whole situation, how bad it was, to be able to advise you and say how bad it is. But generally, if you paid, it's probably good. But there's discretion here. Officers could say, oh, you're playing games or something. But I need to see the exact tax situation in your relationship with the IRS to be able to better guide you. I guess we'll leave it at there. So we'll be back again next Wednesday, 5 p.m. Pacific time, as always, to do a Q&A. Take your questions live here on YouTube, and you all might see the edited version of this later. Download the Ultimate Marriage Green Card Guide free at marriageimmigrationlaw.com. And that's it. Be here next week. We'll also do more free consultation raffles. Till then, goodbye. I hope you enjoyed this educational video. We have a second channel with much more information as well at JQK Immigration Clips. Please check that out. Also, you'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.